All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Presiding Judge,
L'audience est reprise.
the hearing shall resume.
Bonjour à tous.
Good morning to one and all.
Je voudrais juste confirmer
I would like to clarify
la composition des équipes n'a pas
that
changé.
the staffing of the respective teams has not changed. Madam Prosecutor, Mrs. Taylor,
Des représentants.
the legal representatives of victims,
Merci beaucoup.
my thanks.
Avant la pause,
Before
la défense
the brief adjournment, the defence raised a matter
de l'aptitude de l'accusé
going to the fitness of the accused to attend his trial
éventuel examen
and
médicaux.
looking into potential for a medical assessment. And I said
Il y avait un certain nombre
that there were a certain number of files tendered by the defence
maintenant
and that now
résoudre.
we are minded to remedy.
Lecture,
I therefore read
décision de la Chambre.
the decision of the trial chamber.
La Chambre rappelle
The trial chamber
que
recalls
la défense
that the defence
demandé
had requested on the 3rd of July last
que les débats
that
d'aujourd'hui soient
today's
adjournés.
proceedings be adjourned.
Document numéro
Document
927.
927,
Requête à laquelle
application
la Chambre a
to which the
répondu
chamber
négative
uh,
le 8 juillet.
declined to look upon favourably on the 10th of July. The 9th of July, the defence
Également,
also filed another motion.
laquelle elle a
In that motion, it submitted that Mr. Hassan
était inapte
was
à être
unable to stand for trial.
la Chambre a
The
rendu
chamber
hier une
yesterday
décision
handed down
d'écriture
a decision upon that motion
en concluant,
by finding that,
considérant la
bearing in mind
notification de la
the
défense,
notice given by the
le
defence,
document avait été
the
déposé
document had been filed
à un moment
at
inapproprié,
an inappropriate time
lui avait pas
and
été présenté
that
d'informations
it
suffisantes,
hadn't provided sufficient information to the effect that Mr. Al-Hassan was unable to stand trial. Document 952.
la Chambre relève
The chamber
enfin qu'hier, en
recalls
fin de journée,
that yesterday, at the end of the day,
la défense a demandé
the
à la
defence
Chambre
asked of the chamber
reconsidérer
to show reconsideration of its own decision,
l'adjournement
to decline the adjournment of the trial, or, in the alternative,
vouloir autoriser
to
la question
authorise
soit portée
the fact that this matter should be brought before the Chamber of Appeal
l'existence
by
d'informations nouvelles
referring to information de novo,
à ses yeux,
justifying, warranting in the defence's eyes
reconsidération
such reconsideration
en appel.
to be envisaged by the appeals chamber.
Audience de ce matin,
During this morning's proceedings,
la défense a
the defence
présenté
has made an oral
un certain
submission
nombre d'arguments
detailing a certain number of contentions, which in substance
ceux qui ont
takes up
développé
those that were expanded upon in the mentioned, in the aforementioned submissions, in particular in the reconsideration motion that was filed by the defence yesterday. The Chamber recalls
que ce matin
that
jour,
this morning,
durant l'audience,
during our proceedings,
la défense a
the
formulé
defence
explicitement
explicitly formulated
une requête au fin d'un examen
an
médical
application to the effect that a qualified medical assessment be conducted on their client, and that this medical assessment
statué sur la question de savoir
should determine the matter whether the accused is indeed able to stand trial.
en ce qui concerne la requête en
Regarding
considération.
the reconsideration application,
La Chambre
the
relève
Chamber
que cette requête
considers
a été
such
notifiée
application.
à 17h53.
This was submitted at 17:54 yesterday.
Considérant en outre son objet
Additionally,
et son contenu,
bearing in mind its content
elle n'a
and
pas
purpose,
estimé nécessaire
the Chamber does not find it necessary
du bureau du procureur
to hear submissions from the prosecutor
représentant des victimes.
or from the legal representative of victims. The Chamber
Rejette
dismisses the application
et rendra les motifs
and will provide
en temps utile.
a reasoned decision in due course.
En ce qui concerne la requête
I move
d'autorisation
to
de faire
the application for going on appeal.
en France
The Chamber has formally acknowledged this course of action and will hand down its decision in due course
après avoir reçu
after having received responses from the parties and participants.
en ce qui concerne enfin
I move
la requête orale
to
de
the
ce matin,
oral application made this morning. This oral application, by way of reminder,
en substance
takes up in its substance
les arguments
the arguments expanded upon in
récemment déposés par
recently filed motions by the defence.
la Chambre
In light of that, the Chamber reiterates
qu'elle a développé dans la décision
what it said in its own decision
52
952.
qui a été rendue hier
This decision was handed down yesterday,
les reprend à présent
and
pour former
we refer to that to formulate our decision. First,
la Chambre réitère
the Chamber
en
reiterates
reprenant la jurisprudence
by referring to the case law handed down by the Appeals Chamber that
bien que la
even
présente
though
requête
the instant motion is particularly tardy, it
elle est disposée à examiner
it
bien
is
fondée
disposed to address
l'existence
the
de
merits
circonstances exceptionnelles
regarding the exceptional circumstances
justifiant le dépôt
that may warrant
d'une telle requête.
the tardy filing of such an application.
Comme la Chambre l'a indiqué
As
dans le paragraphe
stated by the Chamber in paragraph 26 of its decision 952,
la Chambre
the Chamber
a pourquoi
sees no reason why
la défense
the defence
n'aurait pas pu introduire
would have been unable to file its motion
antérieur.
at a preceding stage of the proceedings. My second point,
La Chambre réitère
the Chamber reiterates
que le dossier de l'affaire
that the case file
peut examiner
contains a number of examples
de la défense
demonstrating the fact that Defence Counsel
a pu recevoir des instructions spécifiques
could have received specific instructions from their client going to a significant
questions
number and a variety of matters, in particular
d'état de santé.
his state of health.
Je me réfère ici
I here refer to paragraph 27 of
décision 900.
the decision 952.
Troisièmement,
Thirdly,
la Chambre considère
the Chamber
que
holds that the application,
implicitement
which implicitly refers to Rule 135 of the Rules of Procedure of Evidence is tardy,
comme la Chambre l'a indiqué
as the
au
Chamber
paragraphe
stated
9,
in paragraph 29 of its 952 decision.
et je cite la décision.
Let me quote from the English.
Should the Chamber entertain the defense request at this stage to discuss the present issue, the defense would in effect be forcing the Chamber to postpone the commencement of trial. The Chamber reiterates in the strongest possible terms that this Chamber will not permit such tactics to be used in the present trial proceedings. Fin de citation.
End of quote.
Par ces raisons,
For these reasons,
et considérant
and
les observations et les informations
considering the submissions and information
présentées,
that has been placed before our Chamber,
la Chambre conclut
the trial chamber concludes
qu'il n'y a pas
that,
été
as things stand,
d'informations
no information,
suffisantes
not adequate information has been made available to the Chamber to warrant a view that Mr. Al-Hassan is unfit for trial.
La Chambre
the Chamber will determine whether Mr. Al-Hassan understands the nature of the charges made against him. That said, the Chamber may order a medical assessment in keeping with the Rule 135 of the Rules of Procedure and Evidence. Accordingly, the Chamber instructs the Registry, in consultation with the parties, to make recommendations before the 24th of July 2020, going to experts who may undertake said medical assessment. The Chamber also instructs the parties to submit their submissions on the recommendations made by the Registry, and this at the latest by the 24th of July 2020. The Chamber will now turn to Mr. Al-Hassan to ask of him whether he understands the nature of the charges, the nature of each individual charge made against him. These charges having been read to him in closed session, and we seek from him a plea, innocent or guilty, under Article 64, Paragraph 8 of the statute.
So everything is crystal clear. You have the Chamber's decision, and we shall now continue with the entering of the plea. Count 1. Torture as a crime against humanity under Article 71F of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? The charge that has been, or charges that have been read to you whilst we were in closed session, that is.
Merci beaucoup.
Judge Mindua, thank you very much. Do you intend to plead guilty or not guilty to this charge? Or do you wish to remain silent?
التزام الصمت لا أستطيع الجواب عن هذا السؤال.
Merci beaucoup.
Thank you very much. The Chamber notes that at this stage of the proceedings, Mr. Al-Hassan intends to not enter a plea, either a guilty or a not guilty plea to this charge.
Chef numéro 2.
Count 2. Mr. Duterte, I have not been able to hear the French or English translation, and in the transcript in English, we cannot see the interpretation of the accused answer unless I've made a mistake. Judge Mindua, Madam Courtroom Officer, please. The Courtroom Officer, I have been informed that there was an interpretation problem from English to Arabic. Could the interpreters please confirm to me that now everything is all right?
Monsieur le Président, tout est en ordre.
The Courtroom Officer, everything is fine. Judge Mindua, thank you very much. Mr. Prosecutor, we shall therefore move on to count 2, and you will ascertain whether everything is going all right, please. Count number 2. Other inhumane acts as a crime against humanity under Article 71K of the statute. Mr. Al-Hassan, Can you confirm to the chamber that you have understood the nature of this charge? Answer: yes, I have indeed understood.
Merci beaucoup.
Judge Mendua, thank you very much. Mr. Anders Al-Hassan, do you intend to plead guilty or not guilty to this charge, or would you rather remain silent?
لا أستطيع الجواب على السؤال.
The accused: I cannot answer this question. I cannot answer this question.
Merci beaucoup.
Judge Mendua, thank you very much. The chamber notes that at this stage of the proceedings, the accused has chosen not to enter a plea, whether as to admission of guilt or a plea of not guilty to this charge. Count 3, torture as a war crime under Article 82C1 of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge?
نعم فهمتها.
Mr. Al-Hassan, yes, I have indeed understood the nature of this charge. Judge Mendua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or do you prefer to remain silent?
لا أستطيع الجواب على هذا السؤال.
Mr. Al-Hassan, I cannot answer this question.
Merci beaucoup.
Judge Mendua, thank you very much. The chamber notes that at this stage of the proceedings, the accused has chosen not to enter a plea, whether to an admission of guilt or not guilty. Count 4, cruel treatment as a war crime under Article 82C1 of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge?
نعم فهمتها.
The accused, yes, I have indeed understood the nature of this charge. Judge Mendua, very well. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or do you prefer to remain silent?
نعم لا أستطيع الجواب على هذا السؤال.
The accused, I cannot answer this question.
C'est-à-dire que vous voulez rester silencieux.
Judge Mendua, that means that you prefer to remain silent. Mr. Al-Hassan, yes, that is correct.
La Chambre prend acte qu'à ce stade de la procédure,
Judge Mendua, the chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge.
numéro 5.
Count 5, outrages upon personal dignity as a war crime under Article 82C2 of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge?
نعم فهمتها.
Mr. Al-Hassan, yes, I have indeed understood, Judge Mendua. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge, or would you rather remain silent?
لا أستطيع الجواب على.
Mr. Al-Hassan, I cannot answer this question.
Très bien. Donc,
Judge Mendua, very well.
la Chambre
So once again,
prend acte
the chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge.
chef numéro 6.
Count 6,
Condamnation
passing of
prononcée
sentences
sans un jugement préalable
without previous judgment pronounced by a regularly constituted court,
assortie de garanties
affording all judicial guarantees which are generally acknowledged as indispensable
prévues à l'article
under Article C4 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mendua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mendua, thank you very much. So you prefer to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 7. Directing attacks against protected objects as a war crime under Article 8(2)(e) little 4 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mendua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mendua, once again, you would prefer to remain silent. Thank you. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 8. Other inhumane acts in the form of forced marriage as a crime against humanity under Article 7(1)(k) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mendua. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mendua. Once again, you would prefer to remain silent. Thank you very much. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 9. Sexual slavery as a crime against humanity under Article 7(1)(g) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Mendua, thank you very much, Mr. Al-Hassan. Do you intend to plead guilty or not guilty to this charge, or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mendua, so once again, you prefer to remain silent. Thank you very much. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 10. Sexual slavery as a war crime under Article 8(2)(e) Roman figures 6 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Mandua, thank you very much. Mr. Al-Hassan, do you intend to now plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer that question. Judge Mandua, thank you very much. So once again, you prefer to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 11. Rape as a crime against humanity under Article 7(1)(g) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Mandua, thank you very much, Mr. Al-Hassan. Do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question, Judge Mandua. Thank you very much. You preferred to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 12. Rape as a war crime under Article 8(2)(e) Roman figures 6 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mandua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer that question. Judge Mandua, thank you very much. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Persecution as a crime against humanity under Article 7(1)(h) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Mandua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer that question. Judge Mandua, thank you very much. So you prefer to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. You may be seated.
The Chamber now intends to make some observations of a procedural nature. The Chamber notes, firstly, that yesterday it received a defence filing entitled Notice of Affirmative Defence, document number 951, in which the defence informs the Chamber of its intention to raise grounds for excluding Mr. Al-Hassan's criminal responsibility, including the assertion that his conduct during the period of the crimes was allegedly coerced. The defence also alleges other grounds for excluding the criminal responsibility of the accused, such as mistake of fact or of law, under Article 32 of the statute, as well as superior orders under Article 33 of the statute. The Chamber takes due note thereof.
La Chambre entend ensuite
Intends to clarify that it is currently seized of a defence termination request to discontinue the proceedings against Mr. Al-Hassan. This is document number 885. The Chamber considered that, given the time limits in which this request was filed, less than 4 weeks before the start of trial, and the time deemed necessary for parties and participants to respond thereto, it was not possible to address this request prior to the commencement of the trial, nor did it consider it appropriate to suspend the commencement of trial in order to address this issue. The Chamber will therefore consider this request in parallel with the trial and in due course. Further, I recall that the Chamber set a deadline for the submission of any observation or objections by the prosecutor and the defence pursuant to Rule 1342 of the Rules of Procedure and Evidence. This deadline is set to the 1st of June 2020, and it was subsequently extended to the 10th of June 2020 following a defence request. In accordance with Rule 1342 of the Rules, the Chamber is now asking the parties whether they wish to raise objections or make observations on the conduct of proceedings subsequent to the confirmation hearing, other than those they have already made, and those that they were not able to raise before the deadline set by the Chamber. In accordance with Rule 1342 of the regulations of the Court, such objections may not be raised in the proceedings without leave of the Chamber. Madam Prosecutor, you have the floor if you have any objections.
Mr. President, we do not have any objections.
Merci beaucoup, Madame la Procureure. Je me tourne vers
Thank you very much, Madam Prosecutor. I now turn towards Counsel Taylor for the defence. Counsel.
Thank you very much, Mr. President. The defence has set out in its pleadings its objections to commencing the trial and substantive testimony before it has had an effective ability to investigate this case. Now, we have done so before the deadline, but we would also respectfully submit that this is an issue that will necessarily be impacted by the events as they arise. And that is reflected by the Chamber's own decisions, which have repeatedly stated that they remain seized of the possibility of receiving defence applications for adjournments depending on how circumstances unroll. So we would respectfully submit that the right to bring these types of objections under Rule 134, subsection 2, should not and cannot preclude the defence from seizing the Chamber in relation to specific investigative issues that we face, have faced, continue to face, and are likely to face before the commencement of testimony. And then that's not an issue that can be time-barred, because once again, it depends on issues beyond our control, and it will depend on how things unroll with COVID and the security in Mali. Thank you.
Merci beaucoup, Maître.
Thank you very much, Counsel. The problem that you raise is one that was already resolved in the previous decision of the Chamber, and the Chamber is currently examining it. So you can be aware of that. The Chamber is not preventing you from addressing it when any issues should arise. I don't know if the prosecutor would like to intervene with regards to this statement of the defence. Thank you, Your Honour. Very briefly, just to say that the objections that have already been made can't be renewed ad infinitum. If there are new elements, then of course they can be raised. That is for the Chamber. But one cannot come back ad infinitum to the same questions.
Voilà. Merci beaucoup.
That's it. Thank you, Prosecutor. Maître Taylor.
Thank you very much. One discrete clarification. We agree that we should not be able to relitigate issues. But when one is dealing with fairness, there's a threshold. And it's possible that the threshold for unfairness might not have been reached at one point in time, but the accumulation of prejudice, the accumulation of factors might bring us over that threshold. So for that reason, we are respectfully submitting that in future applications, we cannot divorce ourselves from what has happened up until this point. And we should be permitted to raise all of the issues in its entirety, so that in future applications, the Chamber is not dealing with things in a piecemeal manner, but is considering prejudice on the basis of the record as a whole and in relation to the threshold of fairness as a whole. Thank you.
Merci beaucoup, Maître.
Thank you very much, Counsel. I understand you very well. And I don't see any problem of fairness. The Chamber is doing its best to ensure it is up to the issue. But the problem is that when you present submissions, the Chamber decides, and sometimes you would seem to come back to the same subject in a new written submission. So you can also pay attention to that. Nevertheless, if you have any observations, you have until Monday, the 10th of 2020, to make them, and the parties and participants will have until Friday, the 21st of August 2020. So the Chamber takes good note of your observations and awaits your input. We are now going to hear the opening statements of the opposite Office of the Prosecutor. I note that yesterday the Chamber, by email, decided to reject the defence objections concerning the material that the prosecutor intends to use during its opening statements, and has given the prosecutor leave to use the material included in the list that it disclosed on the 6th of July, in accordance with Annex A of Decision 788 9 on the conduct of proceedings, you have 4 hours, Madam Prosecutor. I would recall also that in accordance with Decision 867 of the Chamber, you have the possibility to ask that confidential elements in your presentation be only disseminated within the courtroom through a procedure that will make it possible for us to remain in open session. I would like you to indicate if you wish to avail yourself of this possibility and when, whilst recalling that recourse thereto must be as limited as far as possible and must only be for opening statements with a view to adherence to the principle of publicity of proceedings to the maximum degree.
Voilà. Donc, Madame la
That's it, Prosecutor. Madam Prosecutor, you now have the floor, but once again, the Chamber reminds you, nevertheless, that the task of the interpreters and the court reporters will be far more simple if you would speak slowly, and, yet more importantly, the presentations will be clearer and better understood by all who follow them, or will follow them, whether that is here or outside this courtroom. And Madam Court Officer has the task of reminding us whenever it is necessary to do so. Madam Court Officer, nobody will take offence if you call us to order. From time to time, it is indeed incumbent upon you so to do. Madam Prosecutor, you have the floor.
Merci, Monsieur le Président.
Thank you, President.
Monsieur le Président,
Your Honour, your honours.
aujourd'hui,
Today
commence le procès
marks the beginning
attendu,
of the long-awaited trial
inimaginable
of the unimaginable crimes
au Mali.
which have been committed in Mali
Pendant presque un
for almost a year,
d'avril 2000,
between April 2012 and January 2013.
dans la violence
Timbuktu suffered from moral and physical violence meted out by the armed groups Ansar Din and Al-Qaeda in the Islamic Maghreb. Timbuktu, the pearl of the desert, where the population had been living in peace for years,
a été soumis
was subject
à leur dictat.
to their diktats.
Tombouctou
Timbuktu was subjected to their tyranny.
dès qu'ils sont pris la
As soon as they took the city,
les membres
the members of Ansar Din and Akim
des organes
created
de contrôle
organs
de répression,
of control and repression.
notamment créé le tribunal
They created the Islamic Court
islamique
and the Islamic Police,
a été le commissaire
of which Al-Hassan was the key and zealous commissioner. In doing so, the members of these groups exercised a relentless grip on Timbuktu,
sa région
its region,
la population
and the
impuissante.
helpless civilian population. Their plan
Dessein
and design
d'assujettir
was to subjugate
Tombouctiens
the men and women of Timbuktu
à leur
to
contrôle
their power
et pouvoir.
and control.
Leur plan
Their plan and design was to impose
idéologique
their
et religieuse
personal, religious, and ideological vision,
au forceps
and this by force, with a great deal of brutality and abuses constituting crimes against humanity
de guerre
and war crimes under the Rome Statute.
là le cœur
This is at the heart of the present case, the use of violence,
commission
the commission of crimes against inhabitants who were belittled humiliated, assaulted, and, to say it all, subject to a veritable persecution on religious and gender grounds, to which they saw no end, and in which Al-Hassan, the acting and thinking embodiment of the Islamic police, played a central role. Your Honour, Your Honours, I would like to clarify from the outset the following point. This case is in no way directed against Islam, nor is it directed against any religion or system of law or thought. It is simply a criminal case involving grave crimes. You have before you the case of a man, Al-Hassan, who we will demonstrate beyond all reasonable doubt is responsible for crimes under the Rome Statute committed against the inhabitants of Timbuktu and its region, crimes committed against Malians, against his own compatriots, no more, no less. It is for your court to show that individuals such as Al-Hassan cannot join armed groups of any kind, nor occupy part of a sovereign state that has chosen its system of government and impose, through force of arms and violence, on an entire population, precepts and prohibitions under the pretext of implementing their ideological and religious vision. This applies regardless of the ideas, regardless of the principles or religion one claims to follow. That applies irrespective of the rules that one allegedly wishes to apply. It is the very nature of the criminal acts and the pure violence against the civilian population that justifies the prosecution of Al-Hassan before your chamber. The variety of new prohibitions and rules were unmatched in the cruelty with which the institutions established by Ansar Din and Akim and the men such as Al-Hassan punished mercilessly the inhabitants of Timbuktu who were merely exercising their fundamental rights when they didn't bow to the new diktats. Your Honour, Your Honours, allow me to quote the words of an inhabitant of Timbuktu as they embody and summarise the pain and despair of the inhabitants. He says, and I quote, "The town has become a ghost town. Fear in the sense that all the population were hiding away in their houses out of fear of being punished, fear of being humiliated, fear of being brutalized, fear of being assaulted." The word fear is repeated on 4 occasions in this sentence. It is a leitmotif therein. It perfectly describes the calvary that the inhabitants of Timbuktu experienced on a daily basis during the entire occupation. You will see the example of Dedi Omaiga, who is unfortunately now deceased. He was bound to a chair in a public square before the entire population. His hand was amputated in the most brutal way possible with a type of long knife. Who found him guilty? The irregularly constituted Islamic court established by Ansar Din and Akim in Timbuktu to give a semblance of legitimacy to their tyrannical regime. his life was turned upside down. As far as he was concerned, his life was over. The purpose of this punishment was twofold. Firstly, to demonstrate that there was no limit to the power of armed groups in Timbuktu, to demonstrate that nobody could oppose them, even when they committed the most extreme and violent acts, and with good reasons. Ansardine and Akim held all the weapons. And secondly, they wanted to make an example, to strike fear into people, to spread terror, and thus further subjugate and coerce the population into obeying the new rules and prohibitions. And who do you imagine arrested, did you? It was Al-Hassan himself. You will see today Al-Hassan in a video. He totally sanctions this criminal and brutal mutilation. In fact, as my office will prove, Al-Hassan was directly involved in the violence and torture inflicted upon the population, on the men, the women, and the children of Timbuktu. As a commissioner, he held a central function. He worked in a proactive way within the heart of an oppressive, repressive, and persecuting system in which the crimes in this present case were committed. The evidence will show that Al-Hassan led the organization, the management, and was responsible for the functioning of the Islamic police, that Al-Hassan arrested and detained persons, that Al-Hassan conducted investigations on alleged violations of rules imposed by the groups, during which suspects were tortured and threatened in order to obtain confessions, that Al-Hassan referred cases to the Islamic court, that Al-Hassan participated personally in the meting out of corporal punishments by the police, and those decided on by the irregularly constituted Islamic court. And this was done in public or at the headquarters of the Islamic police. Having stated that Al-Hassan worked with the armed groups Ansardine and Acme during the entire occupation of Timbuktu, the very day of the arrival of these groups in Timbuktu, the start of April 2012, a witness saw Al-Hassan and members of the armed groups at the bank, which was soon going to become the headquarters of the Islamic police. We have the evidence that he investigated and wrote at least one police report in a case which was among those heard by the Islamic court during its session of the 7th of May 2012. He remained the commissioner of the Islamic police, a veritable pillar of that organ, until the departure of the armed groups from Timbuktu in January 2013. If you would allow me, Your Honour, to now speak in English.
I will now continue my statement in English. Mr. President, Your Honours, Ansardine and Acme are still active in Mali and Timbuktu region. They pose a grave danger to the safety of witnesses and victims. I shall therefore not go into specific detail here. You have them in the confidential version of the trial brief and other filings. The people of Timbuktu themselves know full well what I'm alluding to, because they have experienced these crimes and suffered physical and mental anguish as a result of them. The evidence of the prosecution will demonstrate that as the armed groups arrive, civilians fled to Bamako or other southern cities, as well as to neighboring countries such as Mauritania or Burkina Faso. They had to leave everything behind. They had to leave their lives behind. Many left to escape the violence, but others remained for one reason or another. Some stayed behind because they simply did not have the means to flee. Others because they had elderly parents to take care of. And others still because they felt attached and responsible for their city or could not resign themselves to abandoning their beloved Timbuktu, especially during one of the worst moments of his history. Those who remained were subjected to a constant climate of fear and oppression. The members of Ansar Dine and Akim made sure of that, continually strutting about with their weapons. In videos, they are publicly available. One can readily see the Islamic police weapons. One can see the judges' weapons next to them during sessions of the tribunal. One would indeed see weapons everywhere, all the time, and that includes heavy weapons mounted on pickup trucks driving around the city. The reign of terror was in place and its tools of enforcement on full display. In this state of occupation and coercion, the Ansar Dine and Akim's members severely restricted. They monitored and controlled everything. A Timbuktu local stated at the time, and I quote, "In Timbuktu, everything has become illicit and forbidden." And another one pointed out that everything was under the control of the armed groups. All aspects of life had indeed fallen under Ansar Dine's and Akim's self-proclaimed rules and prohibitions. Drastic restrictions were imposed on private life, public life, leisure activities, cultural and religious practices, the manner of praying. This affected absolutely everything, even the way inhabitants could or could not dress. Not only were these rules new, but they were also quite alien to the residents of Timbuktu. These imposed rules also denied many customs, traditions, and social practices of the inhabitants, which had characterized the lives of locals in Timbuktu, sometimes for generations. They constituted severe and serious violations of their fundamental rights, such as the right to religion, to private life, or to education. And here I would like to present a brief overview of these rules to demonstrate their breadth and scope. Banning religious practices at the tombs and mausoleums of Muslim saints. Prohibiting celebrations such as the celebration of Maulud. Banning amulets and talismans. Prohibiting statements, masks, and pictorial representations. Complete control over the media, including radio. Banning public gatherings. Closing public schools. Banning music and dancing. Segregating the sexes, including at school. Imposing a new dress code on men, and particularly on women. Men needed to shorten their trousers, and women were required to cover their bodies head to toe. A normal veil was not enough. And in that same vein, banning women from wearing jewelry and makeup, even their traditional clothing, was denied to them. The list is long, and I could go on. The control and domination was total. It was a complete change in the way of life of the inhabitants, as many witnesses will testify. Worse still, any disobedience would result in severe and cruel punishment. In the event of a breach of the new rules, corporal punishment would be applied on the spot by the Islamic police, generally in the form of lashes by a whip. You will see some examples of such measures during the prosecution's presentation of the case. Punishments, including floggings, up to 100 lashes, amputation, and imprisonment were also executed following decisions by the irregularly constituted Islamic Tribunal. Al-Hassan himself pointed out during his interview with our investigators, and I quote, "The residents were not familiar with this punishment. It was the first time that they had seen that. They were scared out of their minds. They couldn't do anything. Everyone was afraid and feared the words of jihadis and terrorists. They were scared of this punishment." Al-Hassan said this. Clearly, Mr. President, Al-Hassan was well aware and indeed involved, as the evidence will show, in this cruel and brutal repression. A witness will testify that it is the Islamic police that was often in charge of organizing executions of sentences, and that he often saw Al-Hassan in charge of them. And this witness will further testify that there was not a single event of execution of sentence in Timbuktu that he attended where Al-Hassan was not present. As a result, Mr. President, it is no surprise if 1,000 kilometers to the south, in Bamako, a witness heard about Al-Hassan. And this witness stated, "Lots of people who fled to Bamako spoke about Al-Hassan and the Islamic police." Mr. President, Your Honors, the prosecutor's evidence will demonstrate that the multiple acts perpetrated against the inhabitants of Timbuktu and its region constituted a real attack against the civilian population. Sentences handed down by an irregularly constituted tribunal, sentences without prior judicial proceedings, torture, cruel treatment, other inhumane acts, outrages upon personal dignity, sexual slavery, acts of rape, attack against historic monuments and buildings dedicated to religion, amongst other offenses. And these are all grave acts and crimes under the Rome Statute which, when taken in their totality, fit the characterization of the crime of persecution, which is also specifically addressed in the Rome Statute. There was religious persecution in Timbuktu. All the rules and prohibitions imposed on the residents stemmed from the ideological and purported religious vision of Ansar Din and Akim. My office has pledged to systematically fight impunity for gender-based crimes where the evidence supports such heinous crimes. In the present case, gender-based persecution was yet another manifestation of this rule by force and terror. Indeed, it was the women and girls of Timbuktu and the region who were targeted and suffered the most. Our evidence will show that women had become the primary targets. Women and girls were pursued into their very homes. They were abused, punished, beaten, imprisoned, and subjected to corporal punishment for a variety of so-called breaches, from failure to wear the prescribed clothing, giving water to a man, not having gloves at the market to pay and receive money, amongst others. And with your indulgence, I would like to briefly touch upon the prison conditions which added to the suffering inflicted on women. The evidence will show that women were kept in inhumane conditions in a room, a small room, at the Banque Malienne de Solidarité, which residents dubbed the women's nightmare cell. It was a 2-square-meter room housing the ATM. And we will show you this infamous cell so that you can see for yourself what these women endured. Women were locked up in a makeshift cell and treated shamefully. At times, not one, but several women were kept in confinement in that limited space, and all this took place in oppressive heat. Some had no option but to relieve themselves in that cell. Our evidence will also show the extreme degree of violence experienced by the women who were subjected to floggings. Hassan knows what I am talking about. He himself was personally involved in organizing the infliction of corporal punishment in public on women accused of adultery. He can be seen on video or photographic material. Some of the details are unbearable and particularly horrid. I am thinking, for instance, of a woman who fell to the ground under the sheer violence and force of the blows. Another woman, punished with 100 lashes, stated, and I quote, "J'ai ressenti beaucoup la douleur physique."
I felt the physical pain. I couldn't birth on my back. I had marks on my body. There were red marks, and the blood had coagulated on my skin.
Hassan was present when this flogging was handed down and executed. But there was an additional level to the horror. I am referring to all the sexual violence the women and girls, sometimes very young, were subjected to. As our evidence will show, a system of marriage was put in place, mainly intended to enable the members of the armed group to satisfy their sexual desires and needs at the expense of the women and girls. Many were hence forced into marriage, confined against their will, and repeatedly raped by one or more members of these armed groups. All that was left of me was a corpse. This is how one victim recounted her ordeal. It should be noted that these women and girls and their families had no choice. Evidence will show that some of the leaders of Ansar Din and Akim, including Hassan, assisted members of the Islamic police to enter into these so-called marriages or participated in marriage negotiations, de facto exerting pressure on families and women through their presence and influence. Overall, the targeting and persecution of women was such that it became emblematic of the physical and moral violence inflicted on all residents of Timbuktu. Mr. President, Your Honors, the victimization of the population, women and men, was significant, and the case before you against Hassan is extremely serious. The prosecution has gathered a wealth of evidence, and this evidence will show that the reign of terror imposed on the inhabitants of Timbuktu during the period of occupation by Ansar Din and Akim groups was without precedent in modern history of Mali and of the people of Timbuktu. The residents of Timbuktu, men and women alike, were relentlessly tyrannized on a daily basis over a period of 10 months. The evidence will also show that Hassan, who perfectly knew the Timbuktu region and the local languages, was a key figure within the armed groups and played a key role in the system put in place to control the city and the region. The unassailable facts in this case point to his guilt and responsibility for all the crimes charged. Hassan was engaging in such conduct unreservedly and with determination. In the evidence that the prosecution will present at this trial, you will see Hassan giving interviews, approving and supporting the policy of the armed groups. You will see him parading with his Kalashnikov and then take a victim to the place where he was executed. Hassan was clearly acting out of his free will. And all of this is corroborated by Hassan's own statement during the interview conducted by representatives of my office in the presence of a lawyer who assisted him and an Article 56 counsel appointed by a judge of this court. Mr. President, Your Honors, back in 2016, Mr. Al-Mahdi was convicted for attacks against religious and historic monuments in Timbuktu. Today, the case against Mr. Al-Hassan is before you with a wider spectrum of crimes. This case represents the continued efforts by my office to bring justice to the people of Timbuktu and Mali, more broadly, who fell victim to those heinous crimes. The suffering endured by Timbuktu and its inhabitants is emblematic of what happened in Mali and the conflict that continues to create misery and suffering in that country. The importance of this trial to the victims of Mali in general cannot be overemphasized. Serious crimes under international law cannot go unpunished. It sends a clear message to all the parties to the conflict operating on the ground in Mali that those responsible for serious violations will be held accountable. Mali deserves justice. The victims of the accused crimes deserve justice. And this court has the opportunity to make an important and tangible contribution to that need and yearning. This trial does not operate in a vacuum. As we embark on this trial, Mr. President, the situation in the center of Mali, but also the rising tensions and related instability and violent incidents in Bamako remain a great concern to my office. All the parties involved must refrain from resorting to violence. The specific and general deterrence of this case is to be appreciated in this larger context. Mali and Malians have suffered immensely. They deserve to have this court on their side. They deserve to have justice done and see that it is done. The ICC stands as a last beacon of hope to those looking to it for justice for the world's gravest crimes. And we must deliver on that promise and indeed that obligation. Mr. President, Your Honors, I thank you for your attention, and I will now hand the floor over to my learned colleague, the senior trial lawyer in this case, Mr. Jules Dutertre, who will present the context in which the crimes in question were allegedly committed with a more detailed outline of the evidence supporting the charges. Mr. President, Your Honors, I thank you.
Presiding Judge,
Merci beaucoup,
my thanks,
Madame la Procureure.
Madam Prosecutor,
Je vous remercie spécialement parce que vous avez fait
specifically so
une présentation en français.
because you made some of your submissions in French and the remainder of your submissions in English.
Alors, maintenant, je crois que nous avons un problème
I think we're meeting with a small
de logistique ou de
logistical problem, one of house management, if I can put it that way, because, unless I'm mistaken, we began at 1:45. Now we have to do an hour and a half as a block session, so we now need to go on to an adjournment of 45 minutes. Is that right, Madam Court Officer? She nods her head in agreement. So this is what we're going to do. Before asking Mr. Dutertre to rise, we shall have an adjournment of 45 minutes before resuming. The hearing is adjourned.